Yeah. Well, friends, we will now take up the second judgment. This particular judgment is called Jaipur Metals and Electricals Employees Organization through General Secretary Mr. Tejram Meena. Jaipur Metals and Electricals Employees Organization through General Secretary Mr. Tejram Meena versus Jaipur Metals and Electricals Limited through its Managing Director and others. This is Civil Appeal number 12023 of 2018 arising out of SLP Civil number 18598 of 2018. And then this particular judgment is dated December 12, 2018. And this particular judgment is again based on the employees challenging the judgment of the High Court of Rajasthan, in which the High Court has refused to transfer winding up proceedings pending before it to the National Company Tribunal and has set aside an order dated 13 April 2018 of the NCLT, by which order a financial creditor's petition under Section 7 of IBC has been admitted. Well, this has got a very recurring history, and then in this case, the Supreme Court observed that under Section 238, the provisions of this code shall have effect notwithstanding anything inconsistent therewith, contained in any other law for the time being, in force, or any instrument having effect by virtue of any such law. And then, friends, the High Court judgment is set aside by the Supreme Court, saying that the NCLT proceedings will now continue from the stage at which they have been left off. Obviously, the company petitions pending cannot be proceeded with further in view of Section 238. The writ petitions that are pending before the High Court have also been disposed of in the light of this fact, and therefore allow the appeal. The appeal was allowed, and then the matter was taken back to the National Company Tribunal, Jaipur bench. So this is another very important landmark judgment, friends, which I would like to bring to your notice. Now the third important case is Innoventive Industries Limited versus ICICI Bank and another. Civil Appeal number 8337-8338 of 2017. This is the judgment of the Supreme Court. And then this is also pertaining to the questions with regard to multi-product companies catering to applications in diverse sectors, wherein the civil appeal is filed and it is dated 31st August 2017. Then, friends, in this case, basically the consortiums were taken into account, and then with regard to master restructuring agreement, the disputes arose, and the matter went to NCLT and then finally went to NCLAT, that is the National Company Appellate Tribunal. And then several issues pertaining to default and pertaining to various other constitutional issues were discussed here. And finally, the Supreme Court has said that the obligation of the corporate debtor was basically unconditional and did not depend upon infusing of funds by the creditors. This is the most important aspect observed by the Supreme Court. Also, the argument taken for the first time before us that no debt was in fact due under the MRA is not something that can be countenanced. And in view of the matter, the Supreme Court is of the considered view that the tribunal and the appellate tribunal were right in admitting the application filed by the financial creditor ICICI, so that there is nothing wrong in admitting, and the proceedings could be further taken in a national complaint tribunal. Accordingly, the appeals were dismissed. Well, friends, the last part of the judgment, this particular today's program, the last judgment is Mobilox Innovations Private Limited versus Kirusa Software Private Limited. This is decided on 21/9/2017, and this is reported in Manipatra, MANU/SC /1196/2017. And then this is a judgment based on the operational debt, the liability thereof, then sections 8 and 9 of the Insolvency and Bankruptcy Code, where the application was filed before the NCLT under sections 8 and 9 of the new code, stating that the operational debt was owed to respondent. The tribunal dismissed the application. Appeal was then filed. Hence, the present appeal was filed. Question is whether there is existence of a dispute between the parties or record of pendency if suit filed before receipt of demand notice of unpaid operational debt in relation to such dispute. And then the court finally held that once the operational creditor has filed an application which was otherwise complete, the adjudicating authority must reject the application under section 952D if notice of dispute has been received by the operational creditor or there was a record of dispute in the information utility. This is the most important aspect, and based on this only today the entire litigation in the country is going on among several national company law tribunal benches. So friends, with this